Islam. One of my first videos. The video that I'm about to do right now is pertaining to a form of civil defense or criminal defense. However, it's fashioned around writing to get our points across in the form of an affidavit. I have an affidavit here that I put together actually two of them because I wanted to throw something out there in terms of what I thought was more clear, concise, and complete in the claim that I was raising and the defense that I was stating. Because I've read quite a few things that are out there, but it seemed to be a mix up, I think, a mix up in terms of the direction that it's going and where it needs to go after that because it's only an affidavit. An affidavit stands to be true, and that's rebutted. We all know that. However, with your affidavit also comes supporting authority behind it in support of it. So it ain't just that an affidavit is going to just get you through there because it's not going to get you through like that. Now, it stands to be rebutted, so whoever's the opposition is, their duty is to rebut it. But let's say, hypothetically speaking, they do rebut it. Now you have a chance to reply to that reply. What you going to do? And let's say they said something that is it's either contrary or irrelevant or basically an attack on what you say because there's already a bunch of history pertaining to Moors making these various different claims. This is why I'm writing right here and I'm going to put it out there. Later we'll do some live stuff for dialogue backwards and forth. However, this actual presentation, in a sense, is connected to the school that I have. We deal with legal research and writing. But I'm just throwing this one out here right now until the website is completed, and I'll put that up so that you can at least follow through and see what we have available, what we offer. However, right now, I got this affidavit here. So let's look at this affidavit. And, okay, I got your proper appellation goes there, am of Moroccan descent and born in America. And I have proclaimed my political status openly, publicly, and notoriously to the world for the following reasons I state. One, I am not the person described in the prosecutor's charging instrument. These charges pertain to one that is the subject of the enactment of H.R. 48 and is the prelude to the 14th Amendment concerning slaves and Congress's authority to make slaves persons to be admitted citizens or to have citizenship, which is outside of the supreme law of the land and is only pursuant to public policy. Period. Two, stated, such presumptuous bubble is burst by the support of evidentiary federal records deposited in the Library of Congress under A222141. Those records contain statements in the form of an affidavit by CM Bay, certified in the record and with a constitutional written proof of freedom and a nationality card. Two, three. Article 3 of the Great Seal Zodiac Constitution states, Moors, referred to as Negroes, could never become equal members or citizens of the United States Republic rights under the document of white supremacy because the present slave labels such as Negro, Black, and Colored left them without the rights that white people are bound to respect except by granted privileges. 4. Furthermore, House Resolution 75, adopted in 1933, as a reference, validates the challenger's claim in writing by recognition of the acquired right of title held by Moors for centuries. A. 5. Wherefore, the challenger's nationality card of the clock of destiny, the written constitution of proof of freedom in the Library of Congress, is the genuine link and proof of fact that illustrates the disconnection in history how we, the Moors of America, and our rights under the treaty were violated and made slaves and stripped of our ancient title, pursuant to bond, excuse me, not pursuant, ancient title, put into bondage and stole our inherited birthrights in violation of Article 14 of the Treaty of Peace and Friendship, Volume 8, Statute at Large, pages 100 to 105, 484 to 487 of 1836. And is in support of my claim for historical purposes, establishing the genuine link between the ancient forefathers and we, the Moorish descendants born in America. That's my affidavit. Okay, so now I think it's basically kind of clear. It's short, and I think it's to the point. Now, we all know they're going to come back with something pertaining to something, not even really that it's contrary to that, or I mean opposition, but it would most likely come back with a bunch of different cases that was put down before. So I'm clicking on here. It would most likely come back with a bunch of cases in opposition with a motion to defeat your argument. However, we broke it up into such a way that now it's your duty to come back with an argument. So, like I said, in the school we have, that I have called the Moorish Sons and Daughters of Light, so we're dealing with legal research and writing. So now this is a part of that type of writing. We got to get to the point. We made it. We have an issue here, okay? We made a claim. We separated it. We got different issues. We got one, two, three, four, 5 issues. Okay. Now, those 5 issues have to be addressed. We know in the court of law these days there's no case law except a bunch of defeats that deals with Moors. Nevertheless, this school in our operation, teaching legal research and writing, our goal is to establish like legal architects. I'm not trying to deal with lawyers, paralegals. I'm a paralegal. We're not dealing with that. We're looking for legal architects. And the reason why I say legal architects is because an architect designs. If we're studying legal research and writing, then we need to be creating a design, okay, from a historical perspective to lay out the groundwork so that we can show the continuity of that right that was overlooked. And I don't think it's not that they don't recognize it. I think it has a lot to do with the position and how we're playing it because a lot of times our brothers and sisters, I think, may be wrong. When I read these cases that I see, I don't see continuity in there. I don't see like I mean, we know it's a validity because we are Moors, but it's the way things is put together. It's like it's some kind of, I don't know, copy paste that's thrown together. We can't throw these affidavits together. And then the other part I want to bring to the attention of the people too is this. This is an affidavit of status. Now, if an incident happened, there's also an affidavit that deals with those facts. Because of somewhere there's a breach along the way that caused you to be caught up on the penal side of the situation. Okay, let's say hypothetically speaking, you had an accident, but instead of the officer dealing with the proper procedures, he just decided to think that because you had this accident, you were drunk. and he just want to throw you in jail. Is that part of his procedures? No. Okay, so let's say you, as you get out of this here, so you're not just dealing with one side of an affidavit that pertains to what he did, but you also talk about the status. So this affidavit deals with that. The other affidavit deals with the actual occurrence of the incident, affidavit of fact. And these are questions that you would pose back to the other party. Okay. And when you're posing these questions back to the other party, you're asking him because he's a police officer. Now, the police officer has a code of conduct, right? Okay. Not just a code of conduct, but a manual that they follow by for that code of conduct. It's called the police patrol manual. All of the states have it. So this police patrol manual, what we're doing here is fix this camera. What we're doing is going through the who, what, where, how, why, and where. Okay, because this police patrol manual, along with that affidavit concerning the incident and those facts, and you also got the affidavit of status. You got a bill of particulars and interrogatories, because you're asking him these various different questions. Okay, that's what the interrogatories are for. That's what the manual is for, like we're talking about. But first, we have this, like I said, you have the status of your affidavit right here. This cannot stand by itself. It has to be supported with a memorandum of law, settled law. Some people say they don't do motion. Then put together a brief then and establish settled law showing why these claims that you're raising is settled law in terms of file in the form of a brief. If you don't do motions, put a brief in. However, if you're trying to move the court, you can't move it by doing what you want to do. There's rules. There's decorum. The same as chess. It doesn't matter. You're not establishing anything else new. You're following what's there. And your forefathers already set this up anyway. So it shouldn't be so difficult for you to learn it. However, in dealing with this here, you have to come behind this with a memorandum of law. In that memorandum of law, we got four things we're dealing with. We're dealing with issue, okay, which is our issues, rulings, whatever type of ruling or reasonings, okay, regarding this subject matter here that we're talking about, and analysts, different types of case law, how the court's seeing these principles. These are principles, and then conclusion. So it's called IRAC, IRAC. Those are the things that go behind this affidavit. And in my school, we deal with that type of writing because it's dealing with legal research and writing, how to find the law, how to put it together, how to discern where the judge made his rulings from, and many other things, as well as material that in order for you to do the exercises to get into creative writing, artistically speaking, for the development of your legal jargon and expertise as you're moving towards the future, we have all that type of material so that you have access. You have access to the necessary tools in order for you to get the work done. You can't tell a person to get a job. You can't give a person a job and if you don't have the tools, you don't have the tools to provide it for. Or you can't ask for a job if you don't got the knowledge and the tools in order to do the work. So if you find yourself in a certain position, you better have the tools in order to get the work done. So that's where this comes into play behind the affidavit. And even on the term of the incidents, there's still settled law regarding that matter as well, because that's going to fall in the civil area. This is in the criminal area here. But this here is to be set up before trial. Why? Because when you ask him the who, what, when you give him that bill of particulars and that interrogatories, those are necessary questions that must be answered before we can go anywhere dealing with this matter. It's very important that that part is established. So now that that's on that side, there's also interrogatory ability particulars or can be on this side, depending upon your defense and your argument, what you bringing to the table. But don't forget, your argument is not with the judge. Your argument is with the prosecution. Okay, so don't forget that. It's very important. So now that you got that settled, then the object now is to dig in, get into the library, and do the research. So we got the first part. We're saying that I'm not a person described in the prosecutor's charging instrument. These charges pertains to the one that is the subject of the enactment of H.R. 48. So, as Moorish Americans, let's go back to what the Sundry Free Moors Act of 1790. It tells you about how Negroes is always the subject of the law. Moors are not the subject of the law. Let's look at American law, period. When we look at the law, we find Indians. Indians got Title 25. That law pertains to them and the things that were set up with this government. And then you got the United States codes. It was basically what everything else the society was dealing with Europeans. If it's pertaining to blacks, blacks is the subject of the law because they don't have a contract in the law because that status is a property status. Regardless if you want to give it a modern term or anything, you still found within the property status of those rights. Although I'll give you a few dollars here and there. So it's important to understand the direction that you want to go so that you don't be led into the wrong directions. So again, we're still on this first part. Part one, remember, this is our issue. And we got issue, ruling, analyst, and conclusion. We're going to try to get there and us talking about it without me supplying documents. Okay, so this is our first issue here that we're not that the subject that these charges pertain to one that is the subject of the enactment of H.R. 48. That's the prelude before the 14th Amendment. Congress had to, if you get into the Congressional Globe, you'll find out in 1868, Mr. William Bingham, a congressman, passed a law, or he didn't pass a law, but it was through public policy that he went before Congress and asked them. He said, "Hey, the slaves are running around. They're free, and they have property, and they're doing this and that, but they have no rights in our courts in which the white man is bound to respect." He said, "But I propose a bill to the act of Congress that would enlarge your power, and in granting this act or this policy that we put forth, it would give you more power. Because right now the slaves are running around, but they are not fit to be citizens because they're just slaves that have been made free. However, if you pass this bill, we can make them persons. And when we make them persons, they'll be fitted for citizenship." So from H.R. 48, we got the 14th Amendment that came behind that. Okay. So when the 14th Amendment came, it came what they call emasi, a blanket, everything that was considered African of Negro blood. Okay. However, we're going to stick to this point on Section 1. So we got that the 14th Amendment concerning slaves and Congress's authority to make slaves persons to be admitted to citizenship outside the supreme law of the land and public policy. So that question, that now become, although it's an issue, it becomes a question because you're doing a memorandum of law. Question presented to the court or question presented to the prosecutor. You got a question presented and you got to give the answer. Are Moors subjects of this particular enactment of legislation. So you're going to have to go deep and you got to do some real research and some writing. But I'm just going to touch on it. I'm going to touch just this point. Just want to touch this point. I'm going to touch this point with this case called Ellen versus Balkan Brown, as far as being the subjects of the law. That case was in 1872. We all know the Dred Scott decision was 1857. It was 1872. It's a California case. Where a white woman or European went before to do some voting, and she was denied. Okay, and so she took it to court because she claimed that she was a citizen of the state of California and the United States under the 14th Amendment. The judge said she was right as far as being a citizen. However, her citizenship under the 14th Amendment was a mistake. And in that case, it's called 43 Cal 43. It stated the purpose of the 14th Amendment was to confer upon a group of people who could not be brought, or persons, not people, persons who could not be brought within the operation of the naturalization law. In the main was of Negro blood, African of Negro blood, whether held in slavery or not, are the descendants of slaves in this country. So when you look at the police powers of the state and where we are today, all of that fall in that area there. The judge said, no white woman, whether born within the jurisdiction of the United States or without the jurisdiction of the United States, owes their citizenship status to this newly enacted amendment. That's interesting. So now we have to support our claim. There's a lot of different ways you can support your claim in there, but I'm going to bring it to your attention. I figure we could talk about an hour, so I'll bring this to your attention here. Now, that case supports issue 1. Okay, and then it goes again. Now we have that case right there. So right behind that, we're talking about AA222141. So I have on point 2, such presumptuous bubble is burst by the support of evidentiary federal records deposited within the Library of Congress. Make sure you have those records, because if you don't, you can make a claim about something, but if you can't prove it, it's not going to be evidence. Evidence got to be authenticated. So you must have your authenticated copy, original. Yeah, almost like a copy. It's an authenticated copy from the original in the records in your argument. Okay, regarding this matter here. Nevertheless, when using this in that argument, you see the contrary part to it. If point 2 is an issue, or rather point 1 is an issue, point 2 further says, hey, that why we are not that, because Moors referred to as Negroes can never become equal members nor citizens of the Union State Republic right order. Okay, Ellen versus Balkan Brown, what did we see? We saw that the purpose of the 14th Amendment was to confer upon a group of people who could not be brought within the operation of naturalization. But they didn't call them Moors, they said Negroes. Africans of Negro blood. Never said Moors. Now, we're just talking. And the reason why is because through our conversation and building on this subject matter here gives us a better scope and perspective on defense. Now, we said that right here in point 2 that bubble was burst. So it says those records contain statements, okay, in the form of an affidavit by C.M. Bay that's certified and in the record with the proof of a written constitutional proof of freedom and your nationality card. I rebut it. That case already said that. And let's go back into the Zodiac Constitution where it says, should they attempt to ignore your inherited birthright, they'd be in violation of the Magna Carta Code. But again, it's how you write this stuff right here. It's very important. So this is the purpose again why we opened up the Moorish Sons and Daughters for Life. So I was a certified paralegal. I put 20 years so far of my time into that type of work as well as being an electrician. Nevertheless, I love law. I love assisting my people, and there's two schools we're involved in. Um, this online course with reaching out to make sure that people, Moorish Americans, can better support and defend themselves in a court of law. The other school that have established is called Urban Technical Trade School. It's an electrical school, so I can teach basic electricity because I'm also licensed in that area. As far as in the schools, as a school teacher, I've been teaching for a number of years. So those two things are very important. Why? Because we need trades, we need income, we need work. As far as the value of the man, it's based upon a lot to do with his character too. So we're building. In order to destroy, we got to build. We can't say, "Hey, stop eating pork and don't give you no beef or no turkey or no lamb." You got to be a substitute for that in order for you to stay strong and to have purpose. So those two things are very needed, and we're going to continue to work on that. However, this writing right here, let's continue on with it so we can look. Okay, we can't forget the IRAP issue, ruling, analyst, conclusion. Because I had a whole host of cases I'm going to beat you up with later on with if I get a chance and you decide to join the school because you're going to have to defend this writing. You got to defend your affidavits. Well, this one right here is dealing with the clock of destiny. Okay, I put this one here together. And then I put another one with the nationality card with the Moorish Science Temple of America. Why? Because it seems like we're going further and further out to sea. Um, I don't see, like I said, as far as writings, putting things together, not copies and pasting, creatively speaking. These are very important for the defense of a people. One, we have to set the precedent. Two, this is not a game. In many instances, you have child custody matters going down, prison going down, homelessness going down. There's a lot of things that we have to pay very close attention to. And you can't take it for granted and think that, oh, I got this and I got a Superman car. Really? Before you became a man, you first started from coming from your mother's womb to a boy and growing to a teenager to a man. It's the same thing with developing yourself and knowledge of self and action and word and deed. A lot of things we don't have to do once we gain certain skills and knowledge. Why? Because we'll see there's no need for that because of the value we see in it, and as well as its usefulness for in our society. As and reason why we will see the usefulness is because we will see how we will be employed, and now become a workforce, a political movement to demand a certain amount of money in the community that the state may have or whoever. We're not trying. I'm not trying to separate you. I thought that the prophet said we're all inclusive. I am a citizen of U period, S period, A period. So we need to stay closer to home in order to get a clear understanding. I'm not going out to sea. I'm staying within whatever is left behind from the Moorish Science Temple of America that the Prophet Noble Drew left, Ali left, and CMA. Those two writings there. The rest, I mean, I've had opportunity to view and to read, and I found it to be quite good. But I'm sticking to the foundations. Why? Because I need to see where you're going with that. I don't feel like going to off a cliff. I got a roadmap. If I'm leaving one city and I'm going to another city, which maybe 100,000 miles away, I need to know how I'm going to get there. Also, if what's the fastest way I may need to get there, and that's also again back to what we're doing here in writing. Okay, so we have one, two, and three. We just talked about these three here. Now, if we're going to talk about AAA 222141, we're really in international law. So we can't really get stuck in domestic law in our argument. That's not the foundation of the claims. Okay? Part of that argument was shown the recognition. Well, that's further down under HR Article 75, I mean, House Resolution 75. However, in his AAA 222141, we got the Zodiac Constitution, which is in contrary to Ellen versus Vulcan Brown, which, if we also reach to their attempt to ignore our inherited birthright, there'd be a violation of their Magna Carta Code. So when you put that law together, it pertains specifically to those people. Say, well, how could you be one of them? Why am I not? Let's look at the terms and construction for the creation of the act itself. Everything has an intent when Congress or legislature puts it together. So if you're talking about Africans of Negro descent, you can't be talking about Moors, because if that's true, you would have mentioned that in the Moroccan Treaty. And throughout the Moorish history, you would also mention things of that nature. You never mentioned that because you can't, because that's not true. And we know that Scipio Louis Africanus, from a Roman general, is where that name is really coming from. So we're not getting into that. Again, but the objective is to write. So we have 5 points that we want to clear out. Okay, these are 5 points that needs a supporting memorandum, okay, of law, a settled law. It's not that it has to be that there are Moorish cases. We're talking about principles of law. We got the first one as a principle of law when we got Ellen versus Vulcan Brown. And then we can use a copy of the Zodiac. I've got a copy of our Zodiac Constitution that goes with that. Okay. With the a certified copy from the Library of Congress. Boom. That's part one. It's totally showing that should you a violation, you ignore my inherited birthright, there's a violation of that. So we have that. But we got to go a little bit higher, because we're making federal claims. Even when we're making a claim that about the Moorish nationality card. On the other one, I'm moving around just a little bit, but they're not that much of a difference in the creation. One is for this area, one is for the other area. It says, I, with your proper appellation, the jurisdictional challenger in this proceeding, supplied my nationality card of the Moorish Sun Temple with its rights, lights, and benefits as a citizen of the U period, S period, A period, which state, I do hereby that you are a Muslim under the divine laws of the Holy Quran of Mecca, comma, capital, I am a citizen of the U period, S period, A. That right there, that's a federal claim. So that falls in, as well as this one over here. They both will fall under the Judiciary Act of 1789. Okay, Section 25, when you're making this particular type of a claim. Again, but it's more to all of this here. And in my library, the material is there for the students to bring the argument around. Let's say, hypothetically speaking, even down to a traffic matter, and you use your nationality card, even in a traffic matter, you used it. But did you set it up to make a federal claim? Because if you made a federal claim and you look at the Judiciary Act of 1789, you would see that if you made a claim and it's under the Constitution or treaty, okay, or commission, um, and the validity is against it, grounds for reversal. So as Moorish Americans, we coming in on the federal grounds, even with your nationality card. So I want you to understand that, or not, I can't say you understand it right away, but look at it, read it for what it is. Okay. And also the same thing is on the nationality card from CMB. All right. Both of these are clear and concise arguments, but also be on your square. Okay? Be on your square. We don't have time for nonsense because of where we're trying to go. So again, this is about an affidavit. And from these affidavits, we have to have a memorandum of law in support of it. But also, depending upon our position at that point, you need a notice before these. The notice is because you want to be heard on a certain day. So that day is blanked out or left out. You leave an open spot because of you give them at least 21 days to this notice. So you got 21 days from the notice, plus you have the memorandum of support with it, and boom, you're clear. All right, now they have that time in order for them to respond back to this right here, which is very important. Okay, I'm gonna continue on before I got a few more minutes left. So we went to Article 3 of the Great Seal Zodiac Constitution that showed that, and going back to Part 1 again, that I'm not the person described in the prosecutor's instrument. But again, it has to be clear and concise. All right, it's very important that. All right, let's go to 4. Okay, there we're talking about House Resolution 75 as a reference, because it's a state record. You should actually get the original copy from the House of Representatives, second from the as far as the chief clerk, so you have an actual original copy in your possession. Okay, it validates the challenger's claim in writing by recognition of the acquired right. Well, that acquired right, whether you gave it to me or not, it still showed you as my inherited birthright in Article 2. Now, we don't got that much time, but we need to, from here, we also got to go into the American Constitution, shouldn't we? We talk about one constitution and we talk about another. We talk about a contract. So we really look at, when we look at the treaty and we look at the American Constitution, that's a contract. Okay. And from that contract, while we're here, we had a constitution written for our protection. So someone is going to say that, well, that was abolished in 1952, rather, excuse me, 1956. Well, our paperwork was established in 52, before 56, where they repealed it. Nevertheless, in the repealing of a law, we see that if you had a right prior to the repealing of that law, you had a right even after that, as long and it's vested right. So, but at another time, we'll go into that. I just wanted to put one video out here, and let's see where we go from here. And I look forward to seeing you guys soon. Peace.